5, 4, 3, 2, 1, start. The Kerala State Road Transport Corporation seeks special leave to appeal to this court from the judgment dated March 9, 1992 of the High Court of Kerala in MFA number 661 of 1986, enhanced compensation in a fatal accident action from a sum of rupees 58760 to a sum of rupees 264,000. Stop. The respondents' claimants are the parents, widow and the children of Thomas Philip, aged 38 years, who died in an unfortunate motor accident that occurred on February 19, 1994 at a place called Plamod Junction at Pullad on Thiruvalla Kothancherry in the state of Kerala, involving a bus owned by the appellant. Stop. We have heard learned counsel on both sides. Stop. Special leave granted. Stop. Stanza. The deceased Thomas Philip, at the time of his unfortunate and untimely death, was employed in the newspaper establishment of Malayala Manorama on a monthly salary of rupees 1032. Stop. These facts and the fact that the accident was the result of actionable negligence on the part of the driver of the bus are not disputed. Stop. Stanza. The Motor Accidents Claims Tribunal LFA in OPMV number 330 of 1984 on some calculations of its own which we find it difficult to approve, determined a compensation of rupees 58,760 to the respondents' claimants. Stop. On appeal by them, the High Court has enhanced the compensation to rupees 2,64,000. Stop. The High Court, in addition to the usual award for loss of dependency, made an award for special damage for funeral expenses, journey to the hospital, treatment expenses, etc. Stop. The High Court has also determined the amount of compensation on account of loss of dependency to the tune of rupees 1,80,000. Stop. The High Court awarded a sum of rupees 50,000 under the head loss of future earnings in the United States of America. Stop. The sum of rupees 2,64,000 was directed to be paid together with interest at the rate 12% per annum from the date of the petition, that is June 15, 1984, till payment. Stop. Stanza. Shri Krishnamurthy Iyer, learned senior counsel, appearing in support of this appeal, urged that this is a clear case of claimants being overcompensated and that the principles of assessment of compensation do not support the award of rupees 1,80,000. Stop. He submitted that admittedly the income of the deceased was rupees 1,032 per month, from which, if the usual deductions for personal living expenses of the deceased are made, the loss of dependency could not be more than rupees 600 to 700 per month, and if that multiplication is capitalized on the number of years purchase appropriate to the age of the deceased bracket or that of the claimants, whichever may be higher bracket close, the amount would not exceed rupees 70,000 to rupees 80,000. Stop. Shri Krishnamurthy Iyer further submitted that even if the usual awards for loss of consortium and loss of expectation of life, which are awards in conventional figures, are added, the total compensation ought not to exceed rupees 1 lakh in this case. Stop. Shri E.M.S. Annam, learned counsel for the respondents' claimants, however, strongly sought to support the award under appeal. Stop. Stanza. We are afraid the reasoning of the High Court cannot be said to be along the settled principles governing the matter. Stop. The reference to and reliance upon the principle in Pickett versus British Rail Engineering Limited, as we may indicate presently, appears to us somewhat misplaced. Stop. It is a different matter. That case itself was statutorily overruled in England. Stop. The determination of the quantum must answer what contemporary society would deem to be a fair sum, such as would allow the wrongdoer to hold up his head among his neighbors and say with their approval that he has done the fair thing. Stop. The amount awarded must be niggardly, since the law values life and limb in a free society in generous scales. Stop. All this means that the sum awarded must be fair and reasonable by accepted legal standards. Stop. Stanza. The rule in common law in Barker versus Bolton 2, enunciated by Lord Elburn, was that in a civil court the death of human being could not be complained of as an inquiry. Stop. Indeed, the maxim actio personalis mortier cum persona had the effect that all actions in tort, with very few exceptions, also became extinguished with that person. Stop. Great changes were brought about by the Fatal Accidents Act 1984/1846 (now Fatal Accidents Act 1976) and the law reforms (miscellaneous provisions) Act 1934. Stop. Under the statute as indeed under the Indian statute as well, there are two separate and distinct causes of action which are maintainable in consequence of a person's death. Stop. There were the dependent's claim for the financial loss suffered and claim for Germany injure loss or damage which the deceased would have had he lived and which survives for the benefit of his estate. Stop. Over.